All right, the next case is HIGHTOWER GEOTECHNICAL versus HBE-FLORIDA Corp. Counsel, can you begin when you're ready?
Please the court. Good morning. I'm Harold Lippis from Jacksonville. I represent the appellant, plaintiff below, HIGHTOWER GEOTECHNICAL Services. I'd like to reserve 10 minutes, if that's what I'll aspire to. The appellees, the defendants below, HBE-FLORIDA Corporation and Hospital Building and Equipment Company, are related corporate entities. One of the entities owned the Ennismark Hotel on the beach here in Daytona. The other one was constructing an addition to that hotel. I'll refer to them collectively in the argument as HBE, just for ease of reference. My client, HIGHTOWER, contracted with HBE to perform what's called soil stabilization work for the project. And to explain it in simple terms, soil stabilization work, if you think of a large excavation prior to constructing a foundation on a structure, you want to secure the walls of that excavation so that they don't cave in, and that's what the soil stabilization work is designed to do. And they did soil stabilization work, and they do soil stabilization work with a relatively easy method. They take pipes which are installed into the ground. The pipes have holes or perforations in them. They pump chemicals called chemical grout into the pipes. It's dispersed through the holes of the perforations, disperses into the soil. It then hardens or gels, forming a solid mass, which referred to in the documents and referred to at trial as a grout wall. HIGHTOWER performed that work until November 16, 2000, when its contract was terminated. Its work was virtually complete at the time of the termination. And it was
What were the alleged deficiencies or defects that led to the termination of the contract?
The contract was terminated on November 16 because of an incident that occurred 2 days earlier on November 14, 2000, when a portion of this grout wall failed. And it was determined that HIGHTOWER didn't perform and that the grout wall failed because it didn't perform. We accept that finding from the trial court. We don't have any quarrel with that finding for purposes of this appeal.
And what did the trial court find as the cause of the failure, if at all?
I'm not sure that the exact cause of the failure is described by the trial court in the final judgment. I don't really remember. But there were allegations at trial that they didn't use the proper chemical mixture. There were allegations that the chemical there wasn't a sufficient amount of chemical because it wasn't thick enough, the wall wasn't thick enough, things of that nature.
Were there any allegations related to the amount of grout being pumped in?
In terms of when you say allegations as to the amount?
I know one of the issues becomes what was the ultimate contract price, and we had a fixed price up to a certain amount, and then it was a per gallon price after that.
Correct.
Any allegations by the other side that you all pumped more grout in than was necessary, or somehow wasted the grout, anything that would argue for a different ultimate contract price as opposed to the deficiency of what was pumped in?
No, there wasn't. And I think the thing that probably highlights that more than anything else, and if I may just grab up, if you want, and what I'm going to do right now, I'm showing you right now, are 2 pages from our brief. And these 2 pages include the testimony of their chief operating officer, who was called as a witness for the purpose of establishing the damages that they were claiming on their counterclaim. And what he testified to, beginning with page 9, and it was consistent with the contract language that included a formula for the damages or determined damages upon termination. And what he testified to, he was asked, and this is at 1462 of the transcript, and this is on their chief operating officer's direct examination, Mr. Matt Nail. The first 2 portions of this document, and they were showing him a document that was not introduced in evidence, it's just for identification purposes. Do they contain the elements that we stipulated to earlier, the contract amount or the invoiced amount from HIGHTOWER and the payments made to HGS? He says, yes, it does. Then he explained the numbers on his damage summary. He could tell the court what he found in that summary. The original contract and the additive changes requested by HIGHTOWER equals an amount of $379,867. To date, we have paid HIGHTOWER $238,7520. Did that amount exceed the original contract amount? Answer, yes, it does. we're asking for a rebate or a credit due to the work that did not meet the performance specifications of $134,344.20. Subtract the cost for correcting the work under the stair tower, which is $91,878.10, and subtracting the disruption damages due to the resequencing of $801,244. And then he goes on to explain that it results in a final amount owed to HBE of $885,674.50. We took his testimony and we just put it into a table. This is the original contract amount that he testified to. The second number, the $238,7520, is the amount paid, resulting in the contract balance of $141,791.80. He then deducted the rebate that they were seeking, the amount that they were seeking to correct the work, and the amount of disruption damages, resulting in the total amount that he was asking for HBE of $885,674.50. And all we're saying, and there's a very limited issue in this appeal, is just take away the $134,344.20, which the trial court said they weren't entitled to. Take away the $801,244 for the disruption damages, which the trial court said they weren't entitled to, and it results in a net judgment in favor of HIGHTOWER of $49,913.70. It's the exact same measure of damages that they used.
What was the basis of their rebate argument?
The rebate argument was that there was work done in the first three phases that HIGHTOWER was paid for, and it included the $134,344.20. I think that was the phase 2 work as it was described by the parties. And what they said was that that work didn't conform to the specifications, and therefore that we weren't entitled to be paid for it. And the court rejected that argument for a very simple reason and a good reason. First of all, they paid for the work. They used it. They didn't correct it. They didn't repair it. And then also it's important to note that one of their witnesses wrote a letter to HIGHTOWER after that phase 2 work was performed, and he said in his letter, if I can find it for just a moment, it was Mr. Trummer. He wrote a letter to HIGHTOWER on September 15. It's 2000. It's Joint Exhibit 47. At the end of the letter, he said, "Only after the work is done, properly inspected, and accepted will the payment be released." That's talking about that $134,000. He was asked about that letter on cross-examination at 1133 of the transcript. We also discussed it at page 13 of the answer brief, and acknowledged that after he wrote that letter and said that the payment wouldn't be released until the work was properly performed, inspected, and accepted, and then acknowledged that they went ahead and made the payment. So that's why the trial court rejected that.
Let me ask, invoices 1, 2, and 3, what you referred to in your brief as phase 1.
Correct.
All right. Work done, payment made except for retainage, and the trial judge found work was accepted.
Yes.
Okay. Invoice 4 went to phase 2. Invoice 5, phase 3, same thing. Work's done,
Accepted.
payments made except for retainage. Now, invoice 6 and 7 goes to phase 4. Now, they apparently had American Excavators do phase 4 for $79,000.
Correct.
All right. Now, you all billed for work which the judge deemed unacceptable, $103,000. Now, your argument, you're assuming that you use the 103 as the contract amount for phase 4. But why should we use 103 as the contract amount for phase 4?
Well, for a couple of reasons. First of all, it was the contract amount that everybody used at trial, including them, number one.
Well, the first question is asked, invoiced amount or contract. It says yes, so it's a compound question. But at the same time, he's asking for money back. So I read Mr. Nail's testimony, but I don't, it's kind of inconsistent with his whole legal position that they're entitled to the money back. But what else is there that the proper contract amount for phase 4 should be $103,000, particularly when American Excavation did it, quote, right for $79,000?
Okay. Let me explain that two different ways. Number one, the amount of the measure of damages said we've got to use some contract values. There was no other evidence of the contract balance other than the amount of chemical that my client pumped in phase 4 as the contract balance. And you say, well, American Excavating came in and they did the work for $79,000. American Excavating didn't pump 1 gallon of ground. What American Excavating did is they came in, they built a new wall adjacent to the wall that was pumped by Hightower. It was called a nail and shotcrete system, where they actually took like a wire mesh. They drove what they called nails, they're actually steel rods, through Hightower's wall, and then they pour like a wall of shotcrete, or what we call concrete almost.
So they utilize some of your client's work to
build the second
a stable wall?
And it increased the PSI of the wall. The PSI in Hightower's wall under the contract was supposed to be 200 PSI, and the wall that American Excavating built increased the PSI from 200 to 2,000. So they actually got a better wall. And the other point that I'd like to make is, really HBE is in a little bit of a pickle, because if you say we can't use the $103,000 as the contract balance, because for whatever reason, because American Excavating came in and they did the work for $79,000. Set aside for a moment that American Excavating did different work and increased the strength of the wall by 10. But if you say we can't use that as the contract balance, then what do we use as the contract balance? And if we don't have a contract balance, then what is it that they can rely on, or that you can rely on in informing the trial court to say that the amount awarded by the judge was appropriate? And that's really, that problem is highlighted by the argument that we made in our brief that the phase 4 work, they can't get it for free. We cited the Koplowitz case that says you're just not entitled to get the phase 4 work for free. You're not entitled to be placed in a better position by virtue of the final judgment than you would have been in had Hightower performed. So under the question that you asked, if you assume that if Hightower had performed, and Hightower then would have been paid $79,000 instead of the $103,000 that it billed, let's just assume that for a moment, then why in the final judgment should the court not only fail to award Hightower the $103,000, but at the same time say, Hightower, you got to pay the $79,000, which is what the final judgment did, which is why we said it gives them the phase 4 work.
So did the judge give your client $5,000 to phase 4?
But he did, if you look at the final judgment, what he did is he gave Hightower $5,000 for work in the north, what he called the northwest corner, which is this area down here. The area that we're talking about, which was most of phase 4, started in what we call the loading dock area on the north side of the project site and extended, the north side of the hotel, and extended all the way along this north wall. And the failure on November 14th occurred under the stairway right here, and Hightower was relieved. American Excavating came, and they put the new wall in along the north wall of the structure. So Hightower got paid absolutely nothing for any of the work it did from the loading dock area all the way along the north wall of the structure. The $5,000 was, as the judge described it, for work in the northwest corner. They got paid absolutely nothing for their work along that wall, and at the same time, the judge said in the final judgment, you got to pay for the amount that they had to pay to American Excavating to put in that second wall. So, for the reasons we said, they can't be placed in a better position.
I need you to explain something in the final judgment about phase 4.
Yes, sir.
The court said, first, there is no evidence that HBA was able to use any of the product installed along the north wall of the existing structure by HGS in phase 4. What is the product installed that's referenced there, the actual grout that's put in?
Yes.
Okay, so the trial judge apparently found that there was grout put in that was not usable. Is that correct?
Correct.
Wouldn't that go to this question of how much the total contract amount was? Because if they were charging for all the grout they put in, and some of the grout the trial court found was not usable, they shouldn't get paid for that, should they?
Well, what they should do is they should go back to the measure of damages that's in the contract that their expert read into the record at pages 13 and 39 and 1340 of the transcript. and say that in the event of termination, the subcontractor shall not be entitled to receive any further payment until the work is finished, and they withheld payment of the final contract. If the unpaid balance of the subcontract price shall exceed the cost of finishing the work, including compensation for additional management and administrative services of contractor, such excess shall be paid to subcontractor.
So, but how much, the key question then becomes, how much is the subcontract price?
The subcontract price is the amount that was invoiced for Phase 4.
Not if it included unnecessary grout, right? If they pumped $500,000 of grout into the ocean under the contract and
I would agree with you.
the trial court found none of it was usable, you wouldn't start from that $500,000. That's not part of the contract price,
No,
right?
but in that instance, then, I would think that you would at least have to have somebody walk into the trial court and say, you know, I'm an expert on chemical grout, and in order for this grout work to have been done properly under the contract, we would have had to pump the equivalent of 100.
Presumably, you had the burden to show what the contract amount was, correct? And under the contract, it would have been the fixed sum, except that there was an override provision. And presumably, the contract price would then be the fixed price plus the cost of any additional grout that was reasonably necessary for the job, correct?
Correct.
If it wasn't reasonably necessary, it doesn't go into the contract price, correct?
Correct.
Didn't the trial court in this case find that some of the grout was not reasonably necessary?
Well, I don't know that he said that it wasn't reasonably necessary. He said it didn't work. It didn't perform, and we don't quarrel.
They were unable to use any of the product installed.
But
So it was useless.
He did say that.
Okay.
But let's just assume for a minute that it was Hightower's burden, and I think it was HBE's burden as well to prove the damages on their counterclaim as to what they would have paid had Hightower properly performed. Somebody has to have evidence of that in the record in order for there to be a recovery. What was the amount that they would have paid? Certainly they shouldn't have gotten it for free. And Hightower got paid.
Well, what they should get for free is anything that you did that was of no value or no use, right?
But if you go to that, if you take it to that point and you say that Hightower shouldn't be paid anything for the Phase 4 work, then you can't hold Hightower responsible for the $80,000 paid to American Excavate. Because then they went and they said, okay,
Your work is worthless. We paid somebody else to do it.
we're going to pay somebody else to do it. And without evidence of what they would have paid us, then there's no evidence in the record to award them that $80,000. And if you do that, then I think, if that's what you conclude, then you have to reverse the trial court's judgment, obviously, because they're not entitled to the $79,000. But with directions to enter a judgment in favor of Hightower for the retainage from Phases 1 through 3 that the courts said we weren't entitled to.
Let me ask you, did an HB expert or supervisor say when they entered this contract with American Excavating that the $79,000 was reasonable value for that north wall? I mean, did one of them say that was a reasonable price as part of their counterclaim?
Did they put on anybody? Well, I mean, they put on evidence through the Jack Gartner, who was the representative from American Excavating, who said that the work was, necessary and that it was reasonable, and we don't have a quarrel with that.
So by their testimony, $80,000 or so would be a fair price for that north wall.
You could reach that conclusion. I mean, obviously that's not what the parties agreed to at trial. I mean, we agreed to, and they used the same damage calculation that we did with respect to the contract.
But as a result of the final judgment, they're getting that $80,000 wall, a minimum $80,000 wall for zero.
They're getting it for absolutely nothing, absolutely for free. And at the very least, if you conclude that we're not entitled to the contract balance based on the number of gallons that we pumped, then you still have to reverse and give us the $26,000 in retainage plus the $5,000 for the northwest corner that the trial court said we were entitled to. But certainly the $26,000 that he failed to award us in our retainage was an error.
Let me ask you a question about the retainage.
Yes.
When are you due the retainage?
You do the retainage after the work is complete and after...
The contract says the retainage shall be held until the subcontractor has substantially performed all the work. In this case, the subcontractor never substantially performed all the work, right? They got thrown off the job. Somebody else had to finish it.
Sure.
Why are you not precluded by the retainage for the contract in which you agreed that it would be held until the subcontractor has substantially performed all the work if you never substantially perform all the work?
Because after you fail to substantially perform and they go out and they hire a replacement contractor to finish your work, this provision can't possibly be intended to mean that they get a windfall by keeping our retainage of $26,000. What it's intended to do, like all retainage in subcontracts is intended to do, is to offer them some protection so that if we fail to perform, they can apply that retainage towards whatever damages they might suffer as a result of our failure to perform. And now if we're at a point where if you conclude that there is no damage, in other words, there's no contract balance that's been proven, they can't get the wall for free, we're still entitled to the retainage for the work that we did that was properly performed.
Thank you.
Thank you.
Please, the court. What we just heard, there's several flaws in the argument that's being presented to you. To first answer your question, Judge Palmer, the court did find that this work did not, the reason for the failure of the stair tower. That occurs in record volume 42, page 7301, and it's part of the judge's...
I'm sorry, you said the court found what?
The reason for the failure of the stair tower.
Okay.
And the court says in that finding that HGS failed to meet the subcontract performance obligations as it did not achieve the required stabilized mass and therefore material breached the subcontract. What the court was referring back to was its findings of fact on page 7392 of the record, where they pointed out that the engineer that came back down and inspected this work, Cecil Aycock, who worked for HDI, in his observation, the curtain neither achieved a consistent unconfined compressive strength of 200 psi, nor did it uniformly achieve the required thickness of 4 feet under the existing building when measured from the leading edge of the existing footing. It's important to note what kind of contract we have here. I heard you say the fixed sum. There was no fixed sum contract involved in this project. The project was to pump gallons of chemical grout at an initial rate of $4.50 per gallon. It was estimated that it would be 35,000 gallons, and that would result in a contract price of $191,000 in round numbers. What we then have is a unit cost contract. Further, the trial court found that this was a performance specification. Now, performance specification requires a contractor achieve a standard of performance rather than just follow a roadmap, if you will, which is what is a design spec. So it isn't enough that he pump any gallons. We start off with a contract balance on this project of zero. Zero. Because until he pumps a gallon of grout that actually contributes to making this stabilized mass 4 feet thick, at least extending at least 2 feet below the lowest excavation, and obtaining a minimum compressive strength of 200 psi, he hasn't met any of his performance obligations. And as we see in Florida case law, and as cited in the brief, when you don't meet your performance specification, then you don't get paid. We have one case in Florida where there was an entire treatment plant built. And because it didn't meet the performance spec, the county didn't have any obligation to pay for what was built. We've got the same thing here.
Let me ask you, even though you don't agree with this point of the trial judge's ruling, did the trial judge find as to phases 1, 2, and 3, invoices 1 through 5, that they had done the work, that they had billed the appropriate amount, and that your client had accepted the work?
I disagree that that was the finding of the trial judge, and I don't disagree with the trial judge's finding. The trial judge found that we accepted invoices 1, 2, 3, and 3.
And 4 and 5.
4 and 5, the trial court relies on Jacqueline v. RS&H to say that we waived any recovery on that. because we didn't object at the time of payment.
Well, all right, even if you didn't accept it, that you'd waive the right to object, and therefore you were obligated to pay the amount invoiced for invoices 1 through 5 for phases 1 through 3.
Exactly.
Okay. Now, on phase 4, how much, if the final judgment is affirmed and the parties comply with the final judgment, how much will you end up paying for that north wall? Will it be zero?
And that's why I'm trying to say this is different. First of all, the trial judge, beginning on page 7283, it's page 7 of his final judgment, describes the problems with phase 2, phase 3, and phase 4. There are problems with it. Second of all,
But he found you were accepted, you used it, you waived any right to complain about it.
he did not find we used it. He found we waived it because we didn't object when we made the payment. And I'll address that with the case law. What he found is put in his order denying motion to amend the final judgment. And his finding was Hightower failed to introduce any evidence that the reasonable value for the work it performed exceeded $243,450.30, and thus did not establish any entitlement to retain its withheld during the course of construction. Now that's his finding of fact. If we're going to challenge that, we can't challenge that as a ruling of law. That's got to be something where they go back through and point to the record that there's not substantial competent evidence to support that finding.
I don't understand what the trial court used as his damage theory. You have a contract that sets forth how damages are going to be calculated, correct?
We have a contract that has A5, and the contract provision in A5 requires that you begin with a contract balance.
Did the court apply the damage formula of A5 to decide the damages in this case?
I would submit that it did.
All right, walk me through how the trial court did that. Tell me where the numbers are that get the trial court to where he ends up with in his final judgment.
In the final judgment, the trial court begins with this acceptance of $238,000 that had been paid as representing the reasonable amount for the contract. The trial court reaches that off of the $191,000 we had as the original contract suggested amount, plus the payment that we made that the court found we waived any right to recover under its Jacqueline case. So that's the beginning point.
That's the contract price?
That's the contract price as established by the court. And if you start from that standing, then the rest of the calculations that the judge has, beginning at page 31 of his order, just fall in place. He then subtracts out the amount that we had to pay American Excavating that he found to be reasonable to repair the work along the wall. And then he also then added to it the $5,000 that he found that we didn't pay for work in the northwest corner.
Here's what I'm trying to figure out. The judge found that their work on the north wall was worthless. Okay?
That's correct.
So you bring in a subcontractor, and you pay the subcontractor $80,000 to do the north wall. Well, it's fine. It's one thing to say you get zero Hightower for your work. But why should they then pay the $80,000 for American Excavating when you were going to have to pay money for the north wall anyway?
Well, the first question is establishing how much should we have paid for the work in the first place. And that's got to be where your inquiry starts.
Didn't your experts say $80,000 was a fair and reasonable?
On the repair work. Now I'm talking about what was the fair and reasonable price to pay Hightower for the work it performed.
So the judge said on the north wall, zero.
And he said for the whole project, it was $243,000.
Well, but didn't he also find that the work they had done for phases 1, 2, and 3 had been invoiced properly and been accepted?
No, Your Honor, he did not. He found that we waived any opportunity to get a rebate for that work. If you look at his order, beginning on page 83, his findings of fact was beginning with phase 2, there is no evidence of any compliance. At the beginning at phase 2, Hightower began to vary its formula that it was using in injecting the grout. Beginning in phase 2, and in fact, what we have is testimony from Hightower's own person, Eric Landry, the person who was in charge of the project, that when he began work for phase 4, he began by installing the grout back at phase 2 to correct the problems that occurred at phase 2.
Let's accept that the value of the work is $243,000, based on the judge's ruling on the motion rehearing, up to the wall on the north tower. Then why should they pay for the north wall? Why should they pay for
What the judge found was $243,000 was a reasonable price for performing all of the work. And the reason why he could do that is the only evidence that we have regarding the reasonable value is testimony both from Matt Nail, who testified he reasonably...
Here's what I'm trying to focus on.
Okay.
If work on phases 1, 2, 3, and 4 was a total value of $243,000,
Right.
according to the judge, and if phase 4 work was 0,
Correct.
that suggests to me that the value of the work on phases 1, 2, and 3 was and the northwest section was $243. So if they've done $243,000 of work for phase 1, 2, and 3 in the northwest corner of phase 4, why do they also have to pay American Excavating's bill?
And here's the issue. What we have is that if you start looking at trying to place where these phases are, the phases were used only as a convenience of measuring the time of performance attempted by Hightower. There is no spatial relationship to phase 3 whatsoever. Phase 1, which they charged $128,000 for in their first 3 invoices, we have no core. So phase 1 is an actual physical place you can put your hand on. Beginning at phase 2, and what you're thinking of is a performance of a contract that would occur in phases that you could actually measure performance at the end of each of one of those distinctive phases. You can't do that here. Because phase 2, the work they began, in phase 4, phase 3 was an area of time where they just couldn't get the formula to work at all. Before they called in Mr. Knotts, Alex Knotts, to come up with the alternative work. So phase 3 doesn't even have a physical space on the project. Phase 2 is what Eric Landry came back in and started repairing, because it too didn't work. That's where we dug the test holes by Tony McMillan to find that the grout was not setting, that there was evidence of grout, but it never did congeal. So the question becomes is, what do you hold HBE accountable for as paying on this contract is the reasonable value of the contract? We would suggest that the only evidence in the record as to the reasonable value that we should have expected to pay for the entire project is $191,000. We were provided information by Rick Hightower, the president, that it was reasonable to expect only 1.5 gallons of this grout per cubic foot.
Wasn't there a change order from your client in August that increased the value of the contract to like $265,000?
Yes, Your Honor, there is. And that change order does say, and as you can see, it's not for changing the scope of the work. There's no additional work being added. We're not adding linear feet of wall. It's only because they say they've had to pump another 17,700 gallons of material. At this point, we're talking about material that's anywhere from 2 to 14 feet below the ground. We're taking their word at this point that this is material that we could use. There's no way that we can inspect it, because at this point it shouldn't have even been congealed. We're still, a week or two away at the time the change order is written for work in August of 2000. When we write this in October, we still haven't started doing the excavation yet to see if any of it performed. What you're trying to say then is HBE has to pay for this work whether or not it accomplishes its performance goal. That would be completely nulling the decision made by the trial court that this was a performance specification. You either have to go back and de novo and say the judge got it wrong, which has not been argued to you, but this was not a performance specification, requiring that the grout pumped in the ground actually achieve the stabilized mass.
What's this show as the total contract amount with extras?
This shows a total contract amount of $264,528.
All right, so what that says is if they perform up to performance standard, that's what you're going to pay.
That's correct.
All right, what did you ultimately pay
We paid $238,000,
All right.
round numbers.
And when you ultimately got the entire project done, what else did you pay?
We also paid $79,000 to American Excavator.
All right, and the trial judge said they have to pay all of that for you, right?
That's correct.
So what you're telling me is your net cost, when all is said and done, will be the 238, not the 264, that you agreed in change order number 1 is what you pay for the entire work to be done, correct?
And that's correct. And if the work had met the performance specification, that is.
But now it now meets the performance standard, right?
It does not meet it.
Currently, it never got.
It never met it. But it did get repaired.
All right, and ultimately you got the project that you contracted for, right?
That's correct.
And
But-
you agreed at some point you would pay $264,500 to get the project you contracted for, correct?
If we had learned that that was necessary pumping, what we found in the testimony from Eric Landry, again submitted to the court, was Mr. Landry pumped grout for whatever reason he wanted to. We also found in phase 2 that they pumped grout that they didn't necessarily have to pump. They never established to the court through their evidence that any of the grout above the 35,000 gallons was necessary to accomplish the project. And that was their burden. They had to put on proof that it would take more than the 35,000 gallons. They didn't do that. They simply can't show that an efficient injection of the grout throughout the project, as they did in phase 1, would not have resulted in a total contract price for 35,000 gallons of $191,000. They made no effort to do that. What they said was, and what they're saying to you today, is regardless of whether any of this grout performed, regardless, we have to pay. So we should have a contract balance of $379,000 because that's how much grout they pumped. Now, there simply was never a stipulation as to $379,000. The demonstrative you see here was a demonstrative again at court. It was not introduced into evidence. And the testimony, as pointed out earlier from Matt Nell, was that this was the contract balance plus the additive changes requested by Hightower to get to the 379. At some point, Hightower bore the liability of being able to demonstrate performance. It had an opportunity at the time it signed its contract to refuse to take on that burden. They could have demanded that the contract be a lump sum contract. They could have demanded that the contract say exactly what they were to pump in the ground and exactly what type of mixture they were to use. But the trial court found even if this had been a design specification, Hightower didn't follow their own guidelines for the mix they would use. So by forcing HBE to pay any more than the $191,000 they expected to pay in the first place, you're forcing HBE to pay for grout that didn't even conform to Hightower's own standards. It didn't even conform to the standards set by Alex Knox.
Did the trial court find, you had made reference to the trial court having found that they didn't prove their work was worth more than the $239,000?
That's correct.
Did the trial court find that the work they performed wasn't worth more than that, or that all of the work required under the contract would not be more than that?
That is what is said, that all the work under the contract should not have exceeded $243,450.
Where do you have a...
This is 7425. It's the last page of the
Final judgment.
order denying motion to amend final
okay.
judgment.
Okay.
And it was Hightower's burden below. They knew it from the pretrial stipulation. The pretrial stipulation, one of the exact stipulations for an issue to be tried was how many units of work did HGS provide that conformed with the requirements of the subcontract, and what is the value of the work that did conform. That was one of the questions to be tried that was agreed between the parties that appeared in the pretrial stipulation. When the trial judge summarized the damages presented to it by Hightower, he refers on page 20 of the final judgment to the first item as total value of work complete per subcontract, not the contract balance. Because if we'd ever talked about contract balance, change order number 1 was the only executed change order. By contract, this is the only thing that could have ever been a contract balance. What you will not find appearing in any of the over 7,000 pages in this record is any reference to this $264,528. It simply was never argued. And it wasn't because that wasn't the issue below. That was not the issue below. The issue below was Hightower on the one state saying that all it had to do was pump because this was a design spec and it met the design spec requirements, and so it was HBE was obligated to pay. And on the other hand, HBE saying it didn't meet it, it was a performance spec, they didn't offer the proof. These issues go to our cross appeal as well. Our cross appeal is looking for a rebate, and it's also looking at the impact that we had from a disruption claim, and we believe that should be reviewed de novo, and that it is also addressing a point of law as illustrated by the 3 federal cases cited. I see I'm out of time.
Thank you, Tom.
I think when we look at what the trial court did, we have to be realistic about the fact that this contract wasn't a fixed price contract for $191,000. It was $191,000. You're pumping chemicals into sand. You don't know how those chemicals are going to disperse, and it says $4.10 per gallon above some certain amount. Phases 1 through 3, the trial court found we were paid for that work. They have no right to a rebate for that work. We were paid nothing for the Phase 4 work and given no credit for the Phase 4 work. Absolutely none. They acknowledge it in the memo they filed in response to the motion for rehearing or
But did the trial court find that the amount you'd been paid, which was $239, was sufficient to cover the entire reasonable cost of the contract?
No. What the trial court found was that that dollar amount, what the court found was we didn't prove, Hightower didn't prove that it was entitled to any more than that. It didn't, and they say right in their motion for rehearing, beginning at the bottom of page 9, however, in the response to the motion for rehearing, however, the record is devoid of any evidence of the cost to stabilize the area had the grouting system been installed as designed. And if you look at the change order that they just showed to you, what it says is, increases the dollar amount to $264,528. That's the amount, by the way, that was accepted and inspected as per Mr. Trummer's letter, but it was only for work through August 18, 2000. It didn't include anything in Phase 4, obviously. And then what they didn't show you is, and this is attached to the invoice number 6, which is part of the appendix, their own project superintendent, Robert McCoy, on October 3rd. He signs a monthly contract billing form, not yet reduced to a change order.
Was the work your client billed for in invoices 1 through 5 in any way related to the North Wall?
None whatsoever. It was completely the work on the North Wall. And if you look at the
So you're saying that change order, $265,000, is for work prior to the North Wall?
Well, there's no dispute or no debate about that. And in fact, if you look at their memo in opposition to the motion to amend the final judgment, they actually, HBE has a nice little summary beginning on pages, at the bottom of page 3 and then continuing on to page 4. And what they say there is, and I'll just down with Phase 4 encompassed 2 areas of work on the project during October and November 2000. The loading dock north, north wall of the existing hotel, and the northwest corner of the site, which you mentioned earlier. This work, included in Hightower's invoices 6 and 7, was the only work that remained unpaid by HBE.
That change order, 265, 266, would that add up to the 238 plus the retainage, the 238 paid plus the retainage for those phases?
Yes, sir.
To the penny?
Yes, and that was in phases 1 through 3, and was long before any work was done in Phase 4 that encompassed no work on the North Wall. So even if we're not entitled to the retainage, and I appreciate Judge Palmer's reading of the contract saying you don't get it until you perform, I think that the logical reading of that is we've got to get that amount. If we're entitled to the work we did in phases 1 through 3, then we're entitled to the retainage for that after we determine what the damages are. But even if you come to that conclusion, they still don't get that north wall for free, and Hightower still gets that $5,000 and change for the northwest corner. But they just don't get that north wall for free, and that's exactly what the final judgment says. Thank you.